everyone! Happy Friday! Or good afternoon, or evening, or night, and happy whatever day it is, wherever the heck you are, whenever the heck you're watching this. Anyway, for me, it's Friday morning, and today marks the last day of our series on the basic sources of international law. I will be almost sad to see it go. Not really. But we're gonna end it up. What? There's a phrase there. We're gonna finish it off with a doozy. Not really. But today on Ramblings with Rebecca, academics are important. It says so in the ICJ. Article 38, paragraph 1D of the Statute of the International Court of Justice, where they lay out the sources of international law, says that judicial decisions and the teachings of the most highly qualified publicists of the various nations as a subsidiary means for the determination of rules of law shall be a source of international law. Woohoo! Okay, so judicial decisions and, academic opinions. Source of international law, right there. Very subsidiary, of course. Helpful in defining and interpreting the customs and the principles that we've talked about for the past couple of days. Of course, no matter how prominent and important you are, an international legal scholar does not get to speak law, into being because of their opinion or whatever. However, it is something that the ICJ says it's appropriate to look at when you're trying to figure out what laws are and aren't binding, in a particular context and that kind of thing. Judicial decisions, like the actual court decisions from a case, are not binding at the international law except to the parties of the dispute, right? So it's only the specific nations who have come and said, solve this between us, we're going to be bound by your decision, go. No other state is bound by that in any way because it's a completely voluntary consent-based system. So there's not in the same way kind of a thought of precedent and that law comes from precedent as it does in many domestic or other legal systems. But the decisions can help us in identifying and understanding which rules and which principles of international law do exist, and the court, is going to enforce them because they are an authoritative pronouncement on it. And then the publicists, the academic bits, major reviews of international law, really prominent articles, that kind of thing. The International Court of Justice rarely, but does in fact, cite academic articles and writings. This has got to be dream, right? You've made it to the top, baby, when the ICJ is citing you. Other tribunals do cite academics quite a lot as far as opinions on, yes, this is or is not customary law, this is or is not a general principle versus an absolute rule, that kind of thing. The International Law Commission is a body of independent experts that has been set up as part of the United Nations, and their job is to codify and kind of figure out what international law is. It was set up because there's a lot of uncertainty over what the heck customary international law really is and just how far the general principles properly go. So this International Law Commission sits down once a year in Geneva and gathers up evidence and write down what they think customary international law is. There's this codification process. And from that, we get a lot of documents about rules between nations, interventions, just opinions on all kinds, but they're not properly opinions, right? They're these draft rules, draft protocols for, here's what, we think customary international law is around this topic based on the principles and precedents that we're seeing. Oftentimes, these ILC draft statements become part of treaties, whether it's between, a global treaty or just treaty in between certain nation states, and or, become part of a UN General Assembly resolution, that kind of thing. So certainly they go places, and generally speaking, probably around half, that's a completely made-up number, but a good number of legal scholars and judges will say that yes, once the ILC has drafted something, we can go ahead and go that it's customary international law and is likely to, be able to be brought against another state party in a dispute. So once the ILC writes up something as part of 1D of Article 38 of the International Court of Justice's statute, good chance that you're able to sue another state about it. And we should, that just made me think of something, we should talk about actual remedies in international law. We'll do that. How do you actually punish someone if they disobey all this kind of stuff? Okay, good. Random thought as I'm sitting here rambling. So we'll take care of that in a later series. We're also going to delve into what these sources actually mean and do for human rights and environmental law.